Commissioners of Taxation versus English, Scottish, and Australian Bank Limited. Defining bankers' duty in handling bearer checks. Introduction. The case of Commissioners of Taxation versus English, Scottish, and Australian Bank Limited was adjudicated by the Privy Council on February 17, 1920. This pivotal case addresses the responsibilities and liabilities of banking institutions when handling bearer checks, particularly in the context of negligence and customer status. The primary parties involved are the Commissioners of Taxation and the English, Scottish, and Australian Bank. Central to the dispute is the alleged conversion of a stolen bearer check initially issued by Mr. A Friend for income tax payment, which was subsequently manipulated and dishonestly utilized by an imposter, Stuart Thalen. Summary of the judgment. The Privy Council upheld the defense invoked by the bank under Section 88 of the Bills of Exchange Act 1909, Commonwealth of Australia, which exempts bankers from liability when acting in good faith without negligence in receiving payment for a customer. The court affirmed that Stuart Thalen was considered a customer within the meaning of the Act and that no negligence on the bank's part was demonstrated in handling the stolen bearer check. The decision emphasized the bank's adherence to standard banking practices and highlighted that the absence of negligence precluded liability for the Commissioners of Taxation. Analysis. Precedents cited. The judgment references several key precedents that influenced the court's decision. Kendall v. London Bank of Australia, 18S R. NSW. 394 established foundational definitions regarding customer status and negligence in banking transactions. Great Western Railway Company v. London and County Banking Company, 1901A C. 414. Discuss the nature of customer relationships irrespective of their duration. Commissioners of State Savings Bank versus Permewin, Wright and Company, 19CL. R. 457. Explore the standard for negligence in check handling, particularly in cases involving paid-in checks. Morrison versus London County and Westminster Bank, 1914 3K. B. 356. Provided legal principles concerning the separate determination of negligence on a per-check basis. These precedents collectively shape the court's approach to defining a customer's relationship with a bank and the appropriate standard for negligence in check handling. Legal reasoning. The primary legal questions revolved around determining whether Stuart Thalen was a customer under Section 88 of the Bills of Exchange Act 1909. The court concluded that Thalen was indeed a customer, emphasizing that the duration of the banking relationship is not a determinant factor. Instead, the existence of a transactional relationship where the bank accepts deposits and honors checks qualifies one as a customer. Regarding negligence, the court underscored that it is a question of fact, influenced by the bank's adherence to standard practices and the specific circumstances surrounding each transaction. In this case, the check amount was not substantial enough to warrant heightened scrutiny, and the bank had acted within the ordinary scope of its operations. Therefore, no negligence was identified. Impact. This judgment has significant implications for banking practices and legal standards concerning check handling. Clarification of customer status. Reinforces that even short-term or newly established banking relationships qualify as customer relationships under relevant statutes. Negligence standards. Establishes that banks are not liable for losses due to stolen bearer checks if they adhere to standard practices and demonstrate no negligence unless the circumstances of the transaction are extraordinary. Banking operations. Encourages banks to maintain robust yet practical verification processes, balancing security with operational efficiency. Legal precedent. Serves as a reference point for future cases involving check fraud and bank liability, guiding courts in evaluating similar disputes.